Found it before you called. Yes.
Are you claiming self-defense?
Yes.
Found it before you called. Yes.
Are you claiming self-defense?
Yes.
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 Found it before you called. Yes.
Are you claiming self-defense?
Yes.
Found it before you called. Yes.
Are you claiming self-defense?
Yes.
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 Good morning. How are we today? It is Friday. Are you guys ready for the weekend? Okay, bunch of stuff going on here. The docket is being uploaded as we speak. There's still stuff hitting it, but there's some motions that have already, or some orders that have already fallen on there that we can go ahead and touch on. A couple of notes I want to make to you guys. Yesterday was a holiday for the court, so the judge had said that he was going to give his ruling tomorrow or yesterday by the end of the day, which he probably did. But his clerk wasn't there to upload everything to the docket. That is why it's just now being uploaded this morning. Okay, so the next thing is the video that I uploaded this morning, which I worked on all day yesterday, has been taken down by YouTube. And I think it has something to do with the fact that I had the police report up on the screen. And I don't know if it has something to do with privacy information. There was nothing in there that wasn't open to the public. So I don't know if it was just if it was a trigger by the system or what. But I do apologize if any of you guys were in the middle of watching it when it got snagged. And hopefully I have put in an appeal. So hopefully they will look at it right away and it will come back up and it'll show back up. And when it does, I'll post it in the community tab that it's open for you guys to view it again. Because it was a good dang video showing the differences between what Sarah says versus what we show, what we have on the police report, what we have on the video cameras, all that. So, yeah, it kind of really made me mad. I want to thank you guys for coming in this morning. Please don't forget to hit that like and subscribe button if you have not already. Wanted to look at these different things. The order granting the defendant's motion for a right to hair and makeup. Let's open up this doohickey. Have y'all ever heard that word, doohickey? It's something we say here in the South. Something I haven't said that in a long time. I don't know why the country in me is coming out lately. It really is coming out big time. Order on defendant's motion for a right to hair, cosmetics, and civilian clothing without restraints for trial. Do you want me to just get to what he says? The motion is hereby granted. Defendant's shackles and handcuffs removed during trial proceedings. I don't think that's a big deal because honestly, they know that. What is she going to do? There's guards all around her. He probably double checked with Orange County Corrections, made sure they were on board with it. And he's like, it's just not that big of a deal. Let's give them this because we're not going to give them this other thing, right? Oh, shoot. You can't see. Hang on. I'm sorry. I had my thing set up differently. Is that better? Sorry about that, y'all. Am I muted? Oh, yeah, right. What is she going to do? Is she going to try to escape? She's not. I don't think we have to worry about her. She's her little bitty self. So they'll just, that one female bailiff man, she could lay Sarah out on the carpet, like with one arm. We'll see something out of like WWE on her. Exactly, Carol. I was thinking that too. The judge is trying to give them something to work with here. But let's read why he said this. So he said, he did say that regarding defendant appearing in civilian clothes for trial and defendant's access to cosmetics and hairstyling throughout the trial, the court reserved ruling on defendant appearing before the jury free from physical restraints. In deciding whether to physically restrain a defendant and what method to use, the court The court must balance its obligation to maintain courtroom safety against the risk that the security measures may impair the defendant's presumption of innocence. A court may order physical restraints only if it's found to be necessary to maintain the security of the courtroom, which we think is what the big thing is there. Before ordering a defendant shackled at trial, the trial court must make a case-specific and an individualized assessment that considers 1, the defendant's criminal history and the nature of the pending charges, with special attention to whether either involved violent acts, 2, whether the defendant has disrupted criminal proceedings in the past, and 3, whether the defendant has engaged in any threatening behavior. There was no evidence that the defendant has any criminal history. The defendant is charged by way of information filed on March the 23rd of 2020 with a single count of second-degree murder. There was no evidence that the defendant has disrupted criminal proceedings in the past or has been wait, I can't say that word, y'all. Contumacious defendant during court proceedings. She's just been a pain in the ass with her letter writing, but that's really can't harm anybody in court. There was no evidence that the defendant has engaged in any threatening behavior. So we gave him that one, right? And of course, he's copied everyone in on that. Okay, let me go back over here to the docket and see what else we got. Another thing that was uploaded since I last saw you guys. Oh, I guess I should say, the hair and makeup thing. Let me just, in case you missed it, they wanted hair and makeup for Sarah. And Owens did get more specific. He was wanting at least to allow his seat fillers to come in and put makeup on Sarah before she entered the courtroom. And they said, okay, we're going to. First he goes, yeah, we'll let you do it. I don't see a problem with that. If they want to bring the makeup in the courtroom and do it in the courtroom, that's fine. But then the Orange County Corrections came back and said, well, what is considered contraband, so she should not be doing that. So it wasn't the judge that said she can't have makeup on. It was pretty much Orange County Corrections. So she got denied being able to wear makeup. Now, are they going to, knowing Owens, are we going to argue this? Possibly. He might say to Sarah, no, Sarah's going to be, can't believe this, blah, 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 blah. And Owens is going to say, look, we got to win. We got to win on the restraints, though. So you don't want to push that. I don't know. He's already ruled on it. Owens is so freaking pushy. I can see him coming back and trying to argue it. All right. So yesterday, was this? I think it was yesterday. Yeah. The state, Dave Cacciatore, uploaded a notice of provision of state's amended witness list. So once again, their witness list has been updated. They're getting people ready. Their subpoenas have gone out, kids. Subpoenas have been out. Trial starts on Monday. Trial starts the next business day. Technically, if today was a Monday, we'd be starting trial tomorrow, but it's not. You know what I mean? So after this weekend, it's on. And then, of course, we got another provision of state's amended witness list. Again, I don't know why they did it twice. Now, remember, they're not showing us the witness list. They've kind of put a gag order on that. So I don't know why they filed this twice. Unless they're letting them know they've mailed a copy over to Owens. Then they brought up something about the exhibit list. So I wanted to show you guys this really quick. And don't worry, I'm getting to the big dog. I'm going to get to the big dog, but I'm going to save that for last. Not to mention the fact that it's 10 pages long, this order about the suppression of her statements. And it's still being uploaded to the docket as I speak. So I can't view it yet. So I'm not trying to make y'all wait on purpose. Although I am kind of enjoying it a little bit. Hee. Just kidding. No, we're still waiting for those 10 documents to hit the docket. Okay, so then we have notice of provision of defendant's fifth amended exhibit list. This is coming from Tony Henderson. So this is the gentleman that doesn't know how to work Zoom that was on the Zoom call, if you guys remember him. They're just stating that they're going to serve their amended exhibit list. They electronically filed it to the clerk of courts. And he says, instead of saying, I sent a copy to, this is crazy, y'all. Look at this. Instead of saying, you know, like all the other things, like anything from the state, it says they copied all of Sarah's attorneys. Because, you know, they say she has 3 right now. And it says they electronically copied them. But Henderson uploads something in their lackadaisy ways. And he says, yeah, I understand that the system will automatically send an e-copy to the other side. Really? You can't even copy the attorneys in on this? How rude. Rude. All right. Still uploading. Now, there was one other thing that was uploaded, which was an evidence control sheet. Let's look at that. And I can't tell who uploaded it, like where it came from. It says 10/2/24. Someone with, it looks like a female's handwriting. And it says a copy of the Orange County Sheriff's Office statements, but it says defense. So I think what this is remember how he uploaded that motion the other day trying to suppress the statements? And he went from having a 5-page motion to a 3-page motion to suppress like 10 minutes before trial started, the hearing started the day before yesterday. And he kept saying, referring to the attachments. He said, well, you got to look at their attachments. I believe these are the attachments. So he also put in there that there was a copy of the warnings of constitutional rights. And there was a copy of the Orange County Sheriff's Office general order. So in my layman terms, I believe that's what that is. It's just saying there was something attached. I guess he physically handed over to them, but it was not uploaded to the docket as of yet. All right. Order denying the suppression. Here it is, everyone. The moment you've all been waiting for. And we'll be back in just a moment after this commercial. I'm just kidding. I'm just kidding. Y'all already know what's going to happen because I know there's a bunch of people in the chat trying to like one up everybody going, I already read it. It said it suppressed it. Okay. Let's get to the meat of it. Let me just go down here and tell you what he says. This is from the judge. 10 pages. I love me some Judge Cranick now, y'all. I do love him. Orders and adjudicated as follows. The motion, the amended motion, and the second amended motion are hereby denied. Whoop, whoop. And what does that mean, kids? You just got cranicked. I love it. Nope. The testimony is staying in, kids. God bless him. We kind of knew he was going to do that because he's going to follow the letter of the law. This man is just, Judge Cranick is very thorough. And I think that's why he wanted to have time after listening to both of them go back and forth and giving their arguments and everything. He wanted to have time to sit down and look at everything again and possibly even go back and reference some of the portions of the video that he watched over the weekend. So let me read to you guys what this says. It's the order on defendant's motion to suppress defendant's statements at the Orange County Sheriff's Office, on defendant's amended motion to suppress defendant's statements at the Orange County Sheriff's Office, and on the defendant's second amended motion to suppress defendant's statement at the Orange County Sheriff's Office. He goes through when they filed them all. Okay. The court, having reviewed the motion, having reviewed the response, having reviewed the amended motion, having reviewed the second amended motion, having reviewed the court file, having considered the testimony and evidence offered by the parties, having considered the arguments offered by counsel for state, and having considered the arguments offered by counsel for defendant, finds as follows. Let me just check the chat. You guys with me? Everybody good? We got over 800 people in here. Please hit the like button if you don't mind. I need the algorithm help. It says, Defendant Sarah Boone is charged by way of an information filed on 3/23/2020 with a single count of second-degree murder. On February the 24th of 2020, the defendant called 911 after finding her boyfriend, Jorge Torrez, deceased. Deputy Kayla Rodriguez arrived on February the 24th of 2020 and spoke to the defendant. Here, let me make this bigger for y'all so y'all can see it okay. I think that's pretty good blown up. Y'all can see that okay, right? Detective Kopsel, I don't know if is it Kopsel or is it Kopsel? I'm struggling with the pronunciation of her name. A homicide detective with the Orange County Sheriff's Office with 6 years experience as a homicide detective and a law enforcement officer since 2013, was the lead investigator of Jorge Torrez's death on February the 24th of 2020. Detective Kopsel arrived at the scene within 30 minutes to 1 hour of Orange County Sheriff's Office deputies arriving. She was briefed, and she performed a walkthrough of the apartment. Thereafter, a search warrant was drafted. Detective Kopsel then made contact with the defendant outside of the apartment for a few minutes and explained procedures of the search warrant. The search warrant was executed with CSI. The defendant's phone was collected after CSI documented the scene. Detective Kopsel wanted to go through the defendant's cell phone to corroborate the defendant's story. The defendant signed a consent prior to the February 24th, 2020 interviews addressed below. So also the defendant's Exhibit 1. Detective Kopsel did not look at the defendant's cell phone, including any videos, prior to the interviews addressed below, as digital forensic did not arrive until approximately 7 p.m. And you guys, if my video was still up this morning that I just dropped, it would show you all of the documentation where this is proven, with the CAD sheet sign in, with the police report. And I'm really, honestly, I'm scared to show you any of it right now because I don't want to get hit again and then take me down off of YouTube. It says Detective Kopsel then made contact with the defendant's ex-husband, Brian Boone. Thereafter, they misspelled Brian's name, I think. Thereafter, Detectives Kopsel and Lowen had an interview with the defendant in the Detective Kopsel's unmarked Nissan Pathfinder at approximately 5 p.m. See also State's Exhibit 1. Detective Kopsel explained that she wanted to have conversation with the defendant after walking the apartment. Detective Kopsel testified that she would not have interviewed the defendant outside of the unmarked vehicle, had no memory of using the words routine, and that everything was explained on the recording. The word routine is not used by Detective Kopsel in any recording. Thank you. And that's what I said. Me and the judge, we were on the same wavelength yesterday. What he was looking at is what I was looking at. What he was looking at, I was putting it on a video. So I don't know why you guys can't see it right now. Okay. Detective Kopsel explained the purpose of this interview, including defendant's prior conversations with Deputy Kayla Rodriguez and Detective Kopsel's desire to get a further understanding of what happened last night and ask the defendant more detailed questions. Thereafter, Detective Kopsel began reading Miranda's as follows. She said, I'm going to read you your rights, but it's just because that's how we do things, okay? So you do have the right to remain silent, okay? Do you understand that? And Sarah said, yes. She said, anything you say may be used against you in court. You have the right to talk to an attorney. You have a right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one, one can be provided for you before questions without charge. Has anyone threatened you or promised you anything to get you to talk to me today? Or get me to talk to me? Sarah says no. Okay. And she says, okay, do you understand what I just read to you? And Sarah says, yes. Okay. Then the judge goes on to say, thereafter, Detective Kopsel interviewed defendant again after the initial digital recorder's memory was full. A second separate recording was initiated. Detective Kopsel confirmed. See, I don't think we've seen that yet. I think there's another piece to that car audio that I have not seen or I have not heard. And it's driving me nuts because I didn't get it in the stuff that I got from the police department, which I thought was weird. Because I got everything that was unredacted from Orange County Sheriff's Office. So it says, Detective Kopsel confirmed with defendant that no additional communications occurred prior to the second separate recording, and Detective Kopsel inquired of defendant prior to asking any other questions. You do understand that you don't have to speak with me if you don't want to, correct? To which the defendant responded, yes. After concluding the interviews, but before leaving, Detective Kopsel had conversations with the defendant about coming to the Orange County Sheriff's Office the next day to address the pending autopsy, and that the detective would have more questions at that time. The detective did not recall speaking with the defendant. Okay, the detective did not recall speaking about the defendant's cell phone, but had the defendant asked about getting the cell phone back, the detective would not have given a specific time frame for returning the defendant's cell phone. Which is true. I mean, she would have never told Sarah, oh yeah, well, you can come by and get it tomorrow. Because if you think about it, and then remember, this is stuff we don't have on audio or we don't have on body cam that occurred at the scene. When an investigation is going on like that and she's not the one reviewing that, you've got a forensic unit over there reviewing the cell phone, she's not going to know what their time frame is. And also, they didn't do the car interview. They did the car interview at 4 p.m. Between 4 and 5 p.m. I think it was like 4:50 something p.m. Then the digital forensic unit did not come on the scene until 7 p.m. to look at the phone and get into it. That is the time when they found the videos that Sarah had made the night before of him in the suitcase. So for Sarah to say that the things that she said up on the stand is complete bogus. Okay, let me go back to reading this. A specific time frame for returning defendant's cell phone, she would have not given her that because she doesn't know what the digital forensic units lady is going to say or do at that point. So even after she had looked at it and what had occurred at that point, and this is on the police report, I can pull it up for you guys and show you once again. The police report said that once they discovered the videos, they closed the phone because they only had like an e-warrant, right? They closed the phone out. They realized a crime may have been committed here. It needs to go into an investigation. And they stopped looking at the phone. They did not pick the phone back up until the following day, which was the 25th, after you had Judge John Kest sign an official warrant for them to dig back into the phone. At that point, on the 25th, was when they saw those videos. I would say the detective saw those videos. So I think everything Sarah was saying was complete bogus crap, trying to get around this. And it's her memory. I love how she said her memory. But no, I, as much as I have dogged Kopsel in the past, I think she did kind of do pretty good on the stand yesterday. It says that the detective had no memory of receiving a call from the defendant the evening of February 24th of 2020. Although knowing Sarah, she probably did call her. She probably called her and asked her all kinds of questions and told the detective tried to tell her her life story, like she always does. And the detective's like, I gotta go. Just come to the station tomorrow. If you guys look at the end of this interview, we're gonna watch it in just a minute here. If you look at the body cam footage of when they first got on scene, the detectives, and when they were trying to do their investigation and Sarah keeps interrupting them, you're going to see how they're trying to tell her it's okay. Yeah. Okay. We got to do this though. So, and Sarah's going on and they're like, yeah, okay, but we've got to go over here and investigate. So we're going to get back to you on that. Okay. Yeah, we understand you're scared about his family. Okay, but we're not going anywhere. We got police surrounding the area. You're fine. And Sarah continues to go on and on and on. Okay, I'll continue reading this. The defendant's testimony largely agreed with Detective Kopsel's testimony, including the timeline of calling 911, speaking with Deputy Kayla Rodriguez, and speaking with the Detective Kopsel. As to the February 24th interview, defendant confirmed that the detective explained that general questions would be asked. Defendant confirmed that she stayed on scene 10 plus hours while the investigation was performed. Defendant's own testimony was that she was under the influence of alcohol from the night before at approximately 1 p.m. the next day. That's pretty freaking bad. That she was under the influence of alcohol from the night before approximately 1 p.m. that day. You know what else, too, that was said right there, you guys, is Jay, when he got back up and asked her, he goes, so did you drink that day at all? And she said, no. Okay, so you didn't drink the day of the 25th. You only drank the night before. And she says, yeah. I don't know. You guys put that together and tell me what you think. However, there was nothing evidencing the defendant being intoxicated or under the influence of alcohol when clearly speaking and interacting with Deputy Kayla Rodriguez. What does that say? It says to me that judge says somebody's not being on the up and up. One moment while I take a sip of my coffee, please. Please hold. The defendant's statement of making a call to the detective between 9:30 p.m. and 10 p.m. on February 24th of 2020 from her ex-husband's home does not line up with the defendant's own timeline of staying at the scene for 10 hours, which began at approximately 1 p.m. The court finds this statement lacking credibility. Oh, damn. I didn't even think about that. I know I'm sure some of you guys did in the chat already, though. Y'all are so awesome. Y'all pick up on this stuff a lot quicker than I do. Oh, you go, Judge Kranick. Okay. He said the defendant claimed that before they left the scene, Detective Kopsel or Lowen would return the defendant's cell phone to the apartment. On February 25th of 2024, the defendant claims that the defendant and the detective had a discussion regarding picking up the defendant's cell phone, specifically that due to detective's pregnancy, defendant needed to come down to the Orange County Sheriff's Office to pick up the cell phone. The defendant's sole reason for traveling to Orange County Sheriff's Office was to pick up the cell phone. The court finds that the defendant's statement regarding picking up the cell phone also lacks credibility. Boom. On February the 25th of 2020, after Detective Kopsel reviewed some of the extraction of the defendant's cell phone by digital forensics and attending the autopsy, the detective requested the defendant to come to the Orange County Sheriff's Office. The detective did not want to approach the defendant in front of her child at her ex-husband's home. Defendant's worry and concern about her son was addressed by Deputy Kayla Rodriguez, and it says see State's Exhibit 1. Okay. It says the state and the defense agree with the February 25th, 2020 interview was custodial. Remember in the hearing, he said, oh, she was in custody? Owens went, wait, she was in custody? I don't know if that was an act or if he was just figuring things out. I'm not sure. I haven't made my decision on that one yet. It says the pith of defendant's argument is contained in this exchange during the beginning of the February 25th, 2020 interview. So Sarah walks in. She's been given some water. And she says, just let us know if you have any time you need water, okay? And I'm going to have you sit in that green chair. And she says, I appreciate you coming in. Yes, ma'am. I want to ask about these when you have a moment. And Sarah pulls out her little written list, right, of the things that she's done, because we know she likes to go over things 10 times. So the detective says, sure. So obviously we received his autopsy report. So I'm going to read you your rights again because we have to talk to you about that. And since I'm talking about that incident, we just have to do it. just like we did yesterday. And Sarah says, normal protocol. Once again, Sarah uses the term protocol. Nowhere did I find anywhere in the body cam footage that I re-reviewed yesterday did either Copsel or Lowen use the term protocol. So then Copsel says, just like we did yesterday. Remember I read you your rights? And Sarah says, yes. And Chelsea says, yeah, it's the exact same thing, but since I'm asking you follow-up questions, I need to read them to you, okay? And Sarah says, sure. And then the detective says, all right, so you have the right to remain silent. Anything you say may be used against you in court. You have a right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one, one can be provided for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk to me? Sarah says, no. Detective says, and do you understand what I just read to you? And Sarah says, yes. All right. Now, so this is the state's Exhibit 1, whether the Miranda warning was sufficient. Let me just check the chat really quick. Oh my gosh, there's a lot of you guys in here. Okay. Am I doing all right? Y'all with me? Everybody good? I guess so. Okay. It says the Fifth Amendment of the United States Constitution and Article 1, Section 9 of the Florida Constitution both provide for a right against self-incrimination. Oh, Lord. That term, self-incrimination, and Sarah in the same sentence just kind of gives me chills. No, it just makes me laugh. Okay. It says that self-incrimination clause of Article 1, Section 9, Florida Constitution requires that prior to custodial interrogation in Florida, suspects must be told that they have a right to remain silent, that anything they say will be used against them in court, that they have a right to a lawyer's help, and that if they cannot pay for a lawyer, one will be appointed to help them. They reference Traylor versus State. Both the Florida Supreme Court and the United States Supreme Court have stressed that there is not talismanic incantation required to ensure that Miranda warnings are sufficiently conveyed. Miller versus State. A court does not examine a Miranda warning as if construing a will or defining the terms of an easement. And he quoted that from Duckworth versus Egan. And it says, rather, the inquiry is simply whether the warnings reasonably conveyed to a suspect his rights are required by Miranda. So it says they're talking about alterations in the original readings and all that, and they reference California versus Prysock. The crucial test for determining whether police gave a proper warning is whether the words in the context used, considering the age, background, and intelligence of the individual being interrogated, impart a clear, understandable warning of all of his rights. Then they quote from Coyote versus United States. It says, the Miranda warning provided by law enforcement to the defendant at the beginning of February 25th of 2020 interview is sufficient under both federal law, Florida versus Powell, quoting Miranda versus Arizona, and Florida law, Thomas versus State, State versus Owens. All right, page 7. The Miranda warning given to the defendant in the instant case is identical to the exemplary Miranda warning identified in Owens. Was it State versus Owens? Yeah, State versus Owens. Okay. As such, the Miranda warning given to the defendant in the instant case was sufficient. Now it says whether the defendant's statements on February the 25th were coerced. Sarah was like, it was like a can of worms. You just jiggle the top and the top falls off by itself and out comes all the craziness. They did not have to coerce her whatsoever. And again, at the end of this, I'm going to replay that portion of her interview. To establish that a statement is involuntary, there must be a finding of coercive police conduct. Baker versus State. Generally, to determine whether a confession is involuntary and coerced, a court must examine the totality of the circumstances surrounding it. Martin versus State. When the voluntariness of a confession is in dispute, it is the state's burden to prove voluntariness by a preponderance of the evidence. That's Herard versus State. There was no misrepresentations of the law regarding any defense. See Johnson versus State. No quid pro quo. No, did I say that right? Quid pro quo. Oh, forget it, y'all. Y'all know I can't speak right. I'm from Alabama. No directly or specifically made promises. No overt act or threat of force against defendant was proved or claimed. No fear of material or physical harm. He's referencing tons of cases here. No hope of material reward. No indication that the defendant was a newcomer to the law based on the 2 times the Miranda warnings were provided between February the 24th of 2020 and February the 25th of 2020. Quick pro quo. I think I just said it right. Okay. That was bugging me. No indication that the defendant is mentally deficient, especially considering the verbiage she used. No threats, delusions, deceptions, or promises. And the defendant was offered water and breaks. Boom. All right. I need to drink some coffee. Hang on. There were no false statements made by law enforcement in order to coerce the defendant to go to the Orange County Sheriff's Office on February the 25th of 2020 based upon the findings above. That's right. Under the totality of the circumstances, defendant's statement on February 25th of 2020 were not coerced. Okay, now they're saying whether the defendant's statements on February the 25th, 2020 were voluntarily made. Oh, Lord. A statement is not compelled within the remaining. Oh, I'm sorry. Let me start over. A statement is not compelled within the meaning of state or federal law if an individual voluntarily, knowingly, and intelligently waives his constitutional privilege. See Miranda versus Arizona. The state must prove by a preponderance of the evidence that a defendant's Miranda rights were waived. To constitute a voluntary waiver, the state must show, 1, that the waiver was the result of a free choice on part of the defendant and not the product of intimidation, coercion, or deception, and 2, that the waiver was made with a full awareness of the nature of the right being abandoned and the consequences of the abandonment. It says only if the totality of the circumstances surrounding the interrogation reveals both an uncoerced choice and the requisite level of comprehension may a court properly conclude that Miranda rights have been waived. Factors relevant to consider include the manner in which the Miranda rights were administered, including any cajoling or trickery, the suspect's age, experience, background, and intelligence. The fact that the questioning took place in the station house, and the fact that the interrogators did not secure a written waiver of the Miranda rights at the outset. The Miranda rights were administered in a normal tone and cadence. There was no rushed or urgent speech. See Chafin versus State. Yeah, I could see where a detective would get excited and read it really fast, and then it would be hard to understand him. There was no delay in the administration of a defendant's Miranda rights. The recorded February 25th, 2020 interview reflects that the defendant understood and acknowledged that she understood her rights. The defendant acknowledged that she understood her rights. It says Exhibit 1. It said it twice. And then it says, evidence supporting conclusion that the defendant voluntarily waived rights to remain silent and obtain counsel when officer read defendant his rights and asked defendant whether he understood each of these rights, is to which defendant responded affirmatively. All right. Whew. The court reincorporates its findings in U and V herein with further show no cajoling or trickery. The defendant was 42 years old at the time she made the statements and appears to be of normal intelligence. Well, I mean, that's your opinion. The February 25th, 2020 interview did take place at Orange County Sheriff's Office, and no written waiver was secured. Under the totality of the circumstances, defendant's statements on February the 25th of 2020 were made with a voluntary, knowing, and intelligent waiver, and this waiver was the result of a free choice on the parts of the defendant and was not the product of intimidation, coercion, or deception, and that the waiver was made with full awareness of the nature of the right being abandoned. Therefore, the motion, the amended motion, the second amended motion are hereby denied. And there we have it. Ooh, I gotta sip some of my coffee. So yeah, what I wanted to do is show you guys the video that I was watching again the last 2 days. And we've seen it over and over and over again. I know I have. Of when the police were on the scene, they first got on the scene there, and it's the portions where the detectives arrive on scene, not the other part. And it also shows the portion of where they tried to go into the apartment, and then Sarah calls them back out because she has questions about her safety. Good Lord. So I wanted to watch that with you guys, if you don't mind, if you have a moment. Let me check with the chat and see if everybody's down for that. You're very welcome, Jay Frazier. I think that's everything I got right now. I need to go work on some more clips for you guys. I need to get some emojis up that have Sarah Boone on them. What else? Oh, thank you so much. I missed a super chat. Hang on. Sup, Rosa? Thank you, Mama. Very nice of you. Great live stream as always. Very nice of you. Thank you for everyone who became a member today. Thank you for Kate for gifting a membership. And Catherine for your super sticker. Mandy Strong for your super sticker. Loba Volcana for your super sticker. JSS, aka the Cat Lady, super sticker. Debbie for your membership. Jeannie for your super sticker and membership. Lady Lex. Gentai came in a member. I know you've been around and you were a member at one point, weren't you? Jennifer Adams, thank you for your comment, super chat. Mary Jo Freilich, thank you for your super chat. Pumpkin Porter, thank you for your super chat and becoming a member. And thank you, as always, Tabitha, for gifting 5 memberships. Michael and Aaron, thank you also for your super chats today. You guys have been amazing the last couple of days. I don't know what happened. Oh my gosh, Abella's just gifted 5 memberships. That's so nice of you. Guys, y'all are amazing. Thank you so much. And I know that everybody appreciates it. I have people every now and then will come to me and say, Carrie, I love your channel, but I can't afford a membership. Times are hard. And I totally get that. And if that's the case for you, don't worry about a super chat. Don't worry about a membership or anything like that. Just watch the stream, hit the like button, share it on your social media. That's a huge way to help the channel grow. And I don't look down upon anybody that can't do that. That's okay. If you can, that's awesome. If you can't, don't worry about it. It's not going to change the way I view any of my peeps here. So I just want to thank y'all for being here with me for so long. My gosh, y'all, we've been on for 4 hours. Why am I doing this to myself, knowing I'm going to be hooked to my computer all day, every day for the next 3 weeks, starting Monday? So with that being said, I think we're going to take a break. I think y'all need a break. Let's take a nice little Sarah Boone break. I'll probably put out some more tomorrow. And I might put something out on Sunday. If I can get something pre-recorded, I'll drop it on Sunday. So thank you all for being here. Say hello and thank you to Bama and Interesting Captures, Laura and Mel in the chat for taking care of us all today so kindly. We appreciate you guys so much. Y'all have a blessed evening and stay safe.